This is case number CR 06245633, State of Idaho versus Stephanie Grisham. I'm Judge Neil Randall. This is the Bingham County Courthouse. It is January 31st, 2025, 9:05 a.m. On behalf of the state, we have Mr. Adam Garvin on behalf of the defense. We have Mr. Dennis Wilkinson. Are the parties ready to proceed?
Yes, Your Honor.
All right. It's my understanding that there is an agreement where Ms. Grisham will plead guilty to the charge of vehicular manslaughter. Is that the case, Mr. Wilkinson?
Yes, sir.
Have you had enough time to speak with this, with Mr. Wilkinson?
Yes, sir.
All right. There's a number of things I want to go over with you. Do you understand what the maximum penalties for vehicular manslaughter are? Okay, I'm going to review those with you. If you have any questions, please let me know. The maximum penalty under the law is up to a $2,000 fine and 1 year in jail. You could also be placed on probation for up to 2 years. You could be required to pay restitution. You could also lose your license. The court could also suspend your license. Do you understand these possible consequences? All right. Ms. Grisham, are you under the influence of any drugs or alcohol this morning? Is there anything about your mental health that might impact your ability to understand what you're doing here today?
I don't understand fully.
Do you understand that you will be waiving your right to have a jury trial where the state would be required to prove you guilty beyond a reasonable doubt?
I do.
You also understand that you'd be waiving your right against self-incrimination, and you'd also be waiving your right to testify in your own defense. You would also be waiving your right to have Mr. Wilkinson cross-examine witnesses that the state might have against you, and you'd be waiving your right to have him examine evidence against you. Do you understand this? You also understand that you'd be waiving your right to the subpoena power of the court, which is power to compel witnesses and evidence to be brought in on your behalf. Do you understand this? All right. Has anybody promised I'd be easy on you if you admitted to this crime? Has anybody made any threats or made you any promises of a reward to get you to admit to this crime? So if you do admit to this crime, it would be done freely and voluntarily? All right, Ms. Grisham, the allegation is that on or about February 1st, 2024, in Bingham County in the state of Idaho, that you did negligently, willfully, but without malice, kill Robert J. Beal while operating a motor vehicle on Wolverine Road. This is a violation of Idaho Code 18-4006-3C and 18-4007. Do you plead guilty or not guilty? Mr. Wilkinson, is there a factual basis for the guilty plea?
Yes, sir.
The guilty plea will be placed on the record. The court will find that was knowingly and voluntarily made. It's my understanding that the parties wish to proceed to disposition. Is that correct, Mr. Garvin?
It is.
Mr. Wilkinson?
Yes, sir.
Are the parties ready to proceed?
Yes, sir.
All right. It's my understanding, Mr. Garvin, that Mr. Wilkinson will proceed first. Is that your understanding?
It is, and I've spoken with the family about that as well.
All right. And the family is in agreement?
They are.
Okay. Mr. Wilkinson, go ahead, sir.
All right, thank you. And if it pleases the court, would you like us to address you from council table, or would you like us to address you from the podium?
Wherever you and your client are comfortable.
Okay. We would like to start, again, if it pleases the court, with Ms. Grisham making a statement to the court.
Certainly. Take your time.
1 year ago tomorrow, it was a regular day, doing the job I loved, and I made the terrible choice to be on my phone while I was driving. I could make a dozen excuses, but I don't want to waste your time. I know better, and I shouldn't have been doing it. After the collision, I was thankful to be alive. I was thankful that it wasn't worse. I was relieved when I got the news that the other occupants were okay, especially since I couldn't get out of my car to check on them because I was stuck in the car. I felt relieved that I had taken the worst of the impact. But when I was told that things had changed for the worse, I was at a loss for words, a loss for thought, and I wish I could have changed places. I would have changed places in a heartbeat. I wish that it was me, and I wish that it was I wish things were different. If I'd had the power to go back and change, I would do it. This past year has been a nightmare, a complete nightmare of never-ending pain mentally, emotionally, physically, and a nightmare I wouldn't wish on anyone. At this point, I need to apologize to so many people. I'm sorry to my friends, my family, my coworkers, the first responders, and the citizens that came to the scene. I wish I would not have put anyone through that day. I hate the fact that I put emotional stress on so many people that love me and care about me. I really wish that I could take back that day. Most of all, I need to apologize to the Beal family, especially Linda. My actions that day took the life of a man that I'm told was a very good man, a man that was loved and that loved many, a man that was not just a pillar in his family, but a pillar in the community that is missed daily. I wish I could have made this apology in person. I need everyone today to know how sorry I am. If I could rewind back to that day and do things differently, I would do that with every fiber in my body. I will not ask for anyone to forgive me because that would just be unfair. I do want you to know that I am truly very sorry and I accept responsibility for my actions. I would also like to make the promise that I will never forget that day. I will never forget Robert Beal. I promise that I have changed, that I will never make that mistake again. I promise to educate others in the same actions I did that day in the hopes that it will save lives. I promise to do better, be better, and I'm very sorry that I took him from all of you. Thank you for your time.
Thank you, Mr. Wilkinson.
The person that you see right now, the person that's expressing this to the court, to the family, is the person that I met. I got the call, about this accident. I got the call about this situation, and probably within a couple of days, I went to Ermac, where Stephanie was in the hospital, and I went to her room, and she's connected to machines, her legs in the air, she's covered in gauze, all of those things. And the person that I met in that room was exactly what the court is seeing and hearing right now. It was a person that had nothing but remorse. It was a person that was expressing to me, even though she was in that state, even though that she was in that condition, a person that was expressing to me that she wanted to change places with Mr. Beal. That doesn't bring him back, and that doesn't change anything. I understand that, but from the very beginning, because for me, and I know that the court has significant experience in criminal defense and obviously running these proceedings, but you see a lot of people in the world that express remorse and express condolence because they have a primary driver, and that primary driver is to save themselves from whatever the consequence of those actions was. And I never saw that from Stephanie. Her knee-jerk reaction, honestly, was to reach out to the family, was to apologize, was to express her remorse. And sometimes it's an unfortunate reality of this system that we operate in, that everyone's told to keep their mouth shut. And so I guess at some level, I'm sorry that it takes us so long to get us to this point. I'm sorry that it takes us so long for her to be able to express what she has wanted to express for the last year. Losing a parent, losing a spouse, losing a grandfather, I mean, it leaves a real hole in people's lives. We know that. Christmas wasn't the same this year. Thanksgiving wasn't the same this year. Going to your brother for guidance, going to your father for guidance, those things don't exist for the Beal family. We understand that. Stephanie understands that. There is no doubt, and I want everybody to know that there is no doubt on our side of this equation that Robert Beal was anything but a wonderful person. It's beyond debate. And from a human perspective, that matters, and I understand that. I understand that in the course of human events, losing somebody like Robert Beal leaves that hole, and it's a big deal. Stephanie understands that, and frankly, she understood that when she was trapped in her patrol car that day. She certainly understood it when she was in the hospital. To her credit, she is supported by a wonderful network of supportive and loving family. And frankly, a person that is like this has to have people like this in their lives that really direct and guide and help a person become who they become. But even from the family perspective, who were also there at the hospital that day, they had the same sentiment. It wasn't necessarily focused on just Stephanie, it was focused on the Beal family and what their loss was. And so from the bottom of our heart, we express absolute and sincere condolences to what happened here. That's the human side, that's the human aspect. From a legal perspective, as the court is aware, a judge is mandated to focus on the defendant. The court has to, is legally obligated to, focus and consider her individual circumstances, her criminal history, her potential for rehabilitation. When a court considers an appropriate sentence, it goes beyond the crime itself, it goes beyond those human circumstances themselves, it takes into account mandated factors for the court to consider. Now, everyone knows Stephanie was a law enforcement officer on that day. She is also a wife, she is also a mother, she is also a daughter, she is also a friend. The outpouring of support that I've seen in this case for her has been overwhelming. I think I submitted to the court something like 16 or 17 letters of support. I could have submitted 100, I suppose, had I wanted to. Everything that we have provided to the court, everything about Stephanie screams that she is a caring and compassionate person devoted to the service of her community. And so I think it is important, and I'm not going to go through these in detail, but I do want to highlight a couple of those letters that talk about Stephanie as a human being. And the first one that I'm looking at is what was labeled Exhibit B for the benefit of the court. And that's the letter from Lori Jorgensen. Lori says on the first page, "We are so proud of Steph. She has touched so many lives in a positive way in both her law enforcement career and in her personal life. She is caring and selfless and constantly helping others succeed in careers and life. Steph is always one of the first to volunteer to help those in need. Many of the people that we have crossed paths with will often tell us to meet Steph is to love her." She goes on, "I cannot imagine the pain that the Beal family felt on February 1st and continues to live with every day. What I do not have to imagine is the constant pain, both physical and mental, that Steph lives every day. The guilt that she carries, seeing the pain in her eyes and in her heart as she tries to navigate life that is forever changed. Her father, Brian Jorgensen, also contained within that same Exhibit B, says, "The consequences have been great. The path ahead for her has been and will continue to be a constant reminder of the unfortunate events on that gut-wrenching day. The life she once knew is not the same physically or mentally. The life in her eyes is not the same. Deep down, I hope every day that she will gain that back. I know she fights both sides of the fence now. I know she's grateful to be alive. I also know she struggles with the guilt of depriving someone else of such. My heart goes out to the Beal family. Although I've not lost a family member in this fashion, I've spent many hours with complete strangers that have. I cannot say I've felt your pain. I can, however, say that I've seen your pain. If I could absorb that for you, I'd certainly try to lessen that." Her husband, Keaton Grisham, who's also a deputy with Bingham County. "Throughout this entire ordeal, Steph has tried to remain the steadfast, loving mother to her only son. Seeing the pain and worry in his young face as he visited her in the hospital was downright depressing. All the while, Steph told him that she would be okay and for him not to worry. She has tried to remain the ever-helpful mother she's always been. But I have seen the struggles of both mother and son because of this. The totality of this ordeal, of this magnitude, cannot be easily put into words, and I think that's true. From Stephanie's perspective, she fully accepts responsibility. She fully expresses remorse. She beats herself up, frankly, and I know this sounds cliche, but she beats herself up probably more than this court's power to levy any sort of punishment. This has been a dark year, and I do believe, well, I know for a fact that the court was provided with a copy of the Avanti mental health care information and report. The counselor also kind of hits on some of these issues that I'm talking about right now, and the counselor says that Stephanie's continued remorse and sorrow for the harm she caused has been evident since the beginning of treatment. Throughout this last year, her symptoms of PTSD have been so severe that it took a number of sessions to simply make her stable enough to engage. From a timing perspective, and I know that I think maybe there was some feelings about when this was set for a change of plea in the sentencing. And I guess by way of explanation, in talking to her counselor, getting Stephanie stable to a point where she could actually unbury some of these feelings that she has and talk about the incident that occurred, it took some time for her to be able to do that. And that was part of the delay, I suppose, in us making our way to this day today. Ultimately, as the court is aware, Stephanie was diagnosed with post-traumatic stress disorder as a result of this, and panic disorder. The prognosis is that it's likely going to require her to engage in treatment, fairly significant treatment for the next 3 to 5 years. So I started this out, I suppose, by talking about the human factors. And I'm segueing into those legal factors that the court has to consider. The first one, of course, as the court is aware, is protection of society. Our Supreme Court, and just sort of common sentencing rationale, would say that protection of society is the most important of all factors. We have to make a determination as to whether or not this human being, this defendant in front of you, poses a threat to society. We typically look at a number of different factors when we make that assessment. In Stephanie's case, she has no criminal history, which is the primary driver typically. She has a full-time job. She has a supportive family. She has always been a contributing member to the community. This was not a crime of malice. There was no intent to harm, which is different from some crimes, obviously, that come before the court. On the third page of Kristen Griggs' report to the court, that first full paragraph kind of in the middle, the counselor notes that Stephanie, with regard to Stephanie, she is not a danger to society and has expressed a hope that others who have been involved in or have read about this tragic accident have learned a lesson and that other lives will be saved because of it. There is no indication whatsoever that Stephanie Grisham is a threat to society, not even remotely. So from that factor, I think that the court should make that finding. She is not, in fact, a threat to society. One thing that I note, and I talk about in the sentencing memorandum, and I think it bears some noting today, is her role as a law enforcement officer. That is not a factor, from a statutory perspective, that would be aggravating. Stephanie is a human being that made a mistake that human beings make. Unfortunately, and this is not this case necessarily, with law enforcement though in particular, it is the most distracting environment for a person to ever operate a vehicle. They are constantly on their phone, they are constantly looking at the computer, they're constantly working and they work within their car. I'm not suggesting that that's necessarily this, but I am suggesting that in Stephanie's case, this is a problem, I suppose. This is an issue. This is something that likely everybody in this courtroom at some time in their life have done, whether they're messing with the radio dial, whether they're looking at their cell phone, whether they dropped their lunch on the floor. Distracted driving is not something that's new. In this case, this had nothing to do with her being a police officer. I understand, I do. In the course of my career, I've represented nearly 300 police officers. Primarily not for criminal cases, primarily administrative, but nonetheless, this is different from a normal sort of case where you would consider her being a police officer as an aggravating factor. There are cases in the world, where a police officer will abuse their authority or abuse their power in order to achieve some gain. This isn't that case. This isn't a case where Stephanie abused her authority, where she abused her power, where she used her police power to commit some crime. That's not this. This is a girl who was texting her husband and caused this horrific accident. So on her behalf, I would ask that the court not consider her status as a police officer as an aggravating factor. One other thing, and I would note this, that people have a knee-jerk reaction, and that knee-jerk reaction is for whatever reason that police officers are treated better in the criminal system than normal people or regular people or non-officers. That is, in my experience, anecdotal as it might be, not true. If anything, officers are constantly held to a higher standard. Prosecutors are reluctant to offer any sort of plea agreements because it is a police officer, and they worry about the community sentiment. Judges are oftentimes hesitant to accept binding Rule 11 agreements, for example, if it's a police officer, because they worry about it too. The fact of the matter is in our present society with social media and the ability to comment and do all of those things that people do from the comfort of their own kitchen, this case, people will be critical of the prosecutor for not charging this as a first-degree murder. People will be critical of me for being a shiesty defense lawyer. People will be critical of this court if the sentence is anything but life. And that's just something that we sort of have to accept. And I think that the magnification on that is heightened when we're talking about somebody that has this community protection role. And I don't think there's anything or any way to get around it. But Stephanie should be treated much the same, exactly the same, as any other defendant coming before the court that is in this position. The second factor that we present to the court, which is also mandatory to consider, is rehabilitation. According to Avanti, there are significant rehabilitation needs, and the Avanti report at the bottom of the first page on Exhibit A says, based on my experience and training, I believe it will take approximately 3 to 5 years for Stephanie to recover to the point where she can function the way that she did prior to the accident. The first year of treatment would be the most intense and would require sessions once or twice a week for a full 12 months, maybe longer. Sessions after that final year may continue weekly, but eventually we would start spacing out sessions to every other week and then see if she could maintain her level of functioning. As she progresses, sessions would continue to be spaced out every 3 weeks and then once a month for maintenance for the last year before discontinuing treatment. Because Stephanie has been suffering from PTSD for almost a year, the first stage may take longer than usual. So what we demonstrate there is that there is, in fact, in this case, an objective diagnosis that will require a tremendous amount of time and resource for her to work through. From a sentencing perspective, it is incredibly important for the court to recognize the rehabilitation aspects that she has in front of her and give her sort of the latitude, the time, and the space to be able to engage in this twice-a-week therapy immediately so that she can start working on the PTSD issues and panic disorder that she has as a result of this. The next factor, of course, is deterrence. A factor to be considered, of course. It's less than protection of society, it's less than rehabilitation, but nonetheless it is a factor. I think we oftentimes forget that deterrence is two-pronged. So, I mean, the first part of deterrence is how do we deter this person from committing a crime in the future? I think our demonstration in terms of her not being a threat to society certainly should show the court that Stephanie, as an individual and as a human being, doesn't need to be deterred. That's just simply not going to happen. The second part, though, of course, is deterring people in society in general. So the question, I suppose, that comes before the court is, do you have to fashion a sentence, and how do you fashion a sentence that deters her and deters society? If that is what the court would consider. Like I said, this last year for Stephanie has been a year of hell. Her PTSD, her panic, her inability to eat, engage in life, engage with her son, the depression, I mean, all of it. She is significantly insufficiently deterred. The community, I mean, at some level, this is Dennis talking. I mean, there are people out there, you know, for example, let's say mandatory minimums deter trafficking of drugs. I don't believe that to be the case. I don't think that the drug traffickers are thinking about the mandatory penalties. I don't think that the death penalty, for example, deters serial killers. It just doesn't. It's the furthest thing from the mind. They're feeding some sort of need that we don't really understand. So the deterrent factor for society, they might read about this, they might understand this, and then they're going to go to lunch today and they're going to be looking at their phone on their way to McDonald's, unfortunately. I do have an idea about, and I'll get to it. I do have an idea about something I think would be far more impactful than jail time in terms of deterrence. So we have to kind of turn our attention to that last factor that the court has to consider, which is retribution or punishment. Our recommendation to you, because you're looking at a variety of things here, a fine, do what you like. We leave that to the discretion of the court. Probation, I personally feel like we should be looking at a 2-year term of probation. The reason for that is that when she's going through the rehabilitation process that she's going to be going through, I suppose that the court would like to see what that progress is. So the probation, I would leave to the discretion of the court as well. In terms of deterrence and in terms of punishment, our recommendation to this court is community service. We have made contact with, and we can incorporate, the Beals to some degree too, however the court would like to fashion this. But we've made contact and made arrangements with a number of different organizations. The first folks that I spoke to was BLACKFOOT High School. BLACKFOOT High School is developing a program where they can incorporate Stephanie's story and Stephanie as a human being to talk to classes about the dangers of distracted driving. They are also intending on having an assembly where she would be permitted to be a keynote speaker to talk to the kids about distracted driving. I was telling Stephanie that when I was in high school, in my health class, and I really can't tell you a single day of high school in class, I really can't, other than the one day when they brought in a guy to talk to us about, and I'm guessing this is community service now at this point. I just thought it was a drunk dude that, out of his own benevolence, was talking to us. But anyway, they brought a guy into my high school to talk to us about drinking and driving. And this guy had drank way too much, and then he ran into a vehicle on 17th Street. Out of my 4 years of high school, and I think back about experiences I might have had in class, that might singularly be the only thing I remember in high school. Listening to this man talk about how he ruined his life with alcohol, and me thinking as a 17-year-old, I don't want to be that guy. I think that if we develop, or if we follow this plan that we have developed, Stephanie can really reach a lot of kids. We can do this at BLACKFOOT High School. I've also talked to Snake River High School and Aberdeen High School. They would like to adopt the same, where Stephanie would have the opportunity to come in to talk to young kids about the dangers of distracted driving. Now, one thing I think that's really good about this is that, and this is where I think the law enforcement background is beneficial, is this really would send a message to the kids that it doesn't matter who you are. You do this, you get charged. You do this, you lose your job. You do this, and you find yourself talking to all of these students about what it was that you did. And I will tell you this too, that not only have we reached out to BLACKFOOT High School, Snake River High School, Aberdeen High School, we've also reached out to develop this same program with District 91 and District 93 in Idaho Falls. I met with, this last weekend, some folks from the Idaho National Laboratory who place a great deal of emphasis on safety training. They are also interested, and will give her the opportunity to make that presentation to them. The only thing that I would say, maybe two things. Number one, doing what I'm proposing right now, I think will be more impactful on the community than anything else. It gives her an opportunity to take a horrible situation and make an effort to educate people and to save lives. I don't think that there is a better way to deal with this situation other than that education to potentially prevent a single person from committing this same crime in the future or saving a life. It's hard to objectively weigh that and measure what that impact would be. but it makes so much sense in her circumstance for her to have this opportunity to educate, because I think she will be impactful. As a side note, I have to say this. Those plans are in progress, and they are going to happen. Unfortunately, I do think that Stephanie's going to have to engage in significant treatment before she's going to find herself in a position where she can meaningfully engage in that. So my recommendation is that she's allowed to engage in that treatment for probably upwards of 4 to 6 months before we actually can get her in and start doing what she needs to do, because it needs to be different, you know? I mean, we can't send her up there in her current state to talk about this. I think she really, to truly and fully engage, she's going to have to get a handle on the PTSD. Which takes us to sort of one of the last factors, I suppose, in punishment, and that's jail. For me, a jail sentence is not a scorecard for how serious the court takes this. It's not a scorecard for how tough the prosecution is, and it's not a scorecard for what the community might consider here. You know, 1925-21 Idaho Code says that the sentencing court should always consider placement in the community and not jail, considering the factors of sentencing first. In this case, we have compelling reasons with regard to the jail situation. And I do think about, you know, what is jail? Is jail a time where Stephanie can contemplate how horrible her actions were? Are we sitting her in there so she can think about how bad this was and how bad she is, and cause some sort of deterrent impact on her? Because I'm telling you right now, she is deterred. She has lived in a jail of her own mental making for the last year, and there, frankly, is very little to gain by jail time. Our counselor agrees. So on the last page of the counselor's recommendation or note to the court, she says, I actually believe that any time served would be best served working with the youth in this region, going to schools, and giving assemblies on the dangers of inattentive driving or using a cell phone while driving. Being in a safe, controlled environment is truly an important part of her recovery, and I believe jail time will negatively impact her in a variety of ways. So hopefully there is an alternative way of repaying her debt to the family and to society rather than just punishment. She goes on, there is no punishment worse than what she's been living through every day and having to carry responsibility for the death of another person. I am attaching Stephanie's initial assessment, diagnosis, treatment plan for your review. I hope this is helpful information. And I guess I have to double down on that. It's not a scorecard. Whenever the court is fashioning a sentence, that sentence should have some rationale. It should have some rationale to some aim or goal. And in Stephanie's case, we do not need to lock her up to protect society. We do not need to lock her up to rehabilitate her. If we want to deter the community, the best way for us to do that is to get her out in the community and tell her story and talk about the horrors of what occurred on February 1st of last year. Now, the reality of this, I suppose, is that as I said earlier, a certain segment of the community or society is always going to be critical of what the court does. The truth of the matter is, and I'm sure the court has a grip on this to some degree. I know that the prosecutor will comment on it as well. But about the last, and we sampled this in my own office, about the last 10 misdemeanor manslaughter cases we've dealt with, we've seen sentences ranging from 0 to 25 days. We had one in Idaho Falls last week, although it was amended to a reckless or inattentive where no jail time was given. There was, in fact, a factual similar case in Bingham County last year, which was State versus Harrington, which is CR 06-23-8791. In that case, which is factually identical to this case, a plea agreement was reached where the state recommended a suspended jail sentence of 180 days and a year of formal probation. Ultimately, Judge Colson gave that defendant 15 days. So what I see when we're handling these cases is that sort of range from 0 to 25. That most recent and identical case in Bingham County, I see a jail sentence of 15. I'm asking that we not treat Stephanie Grisham any different than we treat any other defendant that comes before this court. I don't think that it's the inconsistency of the state's recommendation that should govern what the court should do, but that the court should apply the sentencing factors. You will not find a better person than Stephanie Grisham when you apply those mandated factors. She is not a threat to society. She has grievous rehabilitation needs. She does not need to be deterred. Jail in this particular case, like I said, is not a scorecard for what happened here. It truly isn't. I honestly don't think that there is a sufficient number of jail days that equate to the life of Mr. Beal. It just doesn't work like that. If the court is inclined to impose jail, we would ask for a couple of things. Number one, we would ask for facility options. We would like to serve any time not in Bingham County, and that's mostly because Stephanie knows a lot of the Bingham County defendants and those in jail. We would like to look at either Jefferson County or Clark County. We would ask for options. She does work full-time, as the court is aware. If that can be done on work release, if it can be done on weekends. We would also stipulate and agree to home detention if the court were inclined to consider that as well. I guess I feel like I'm on my hands and knees, and I'm just begging the court to consider those factors and to see Stephanie for who she is. I mean, she's a wife, she's a mom, she's a person that was involved in this horrible accident. I think if the court applies these factors, the court should treat her the same as it would treat anybody else. Thank you.
Thank you, Mr. Wilkinson.
February 1st, 2024. So tomorrow will be 1 year ago. Robert Beal sat on the side of Wolverine Road in his wrecked Dodge Ram, lodged against the steering wheel and unable to get out on his own. He waited until emergency crews arrived, and then waited, conscious, until they were able to cut the vehicle apart and extract him. He then died before he could be transported to the hospital. Today's sentencing is about the value of Robert Beal's life. Sergeant Maddenford summarized what or why Robert Beal is dead as follows. Deputy Grisham was traveling approximately 56 to 59 miles per hour at impact. Robert Beal was traveling approximately 45 to 49 miles per hour at impact. The speed limit was 50 miles per hour. Deputy Grisham drove left of center into Robert Beal's half of the road, causing the crash. Based on the scene evidence, the entirety of Deputy Grisham's vehicle was left of center at impact. The dash cam video showed a repeated pattern of Deputy Grisham driving left of center. In an earlier portion of the report, Sergeant Maddenford listed 27 times Deputy Grisham drove left of center during the approximately 17 minutes of dash cam available. Many of those times were as Deputy Grisham was driving on a curving 2-lane mountain road, and may be attributed to reasons other than distraction. But Detective Hewitt's investigation showed that a number of times the driving left of center didn't have any other obvious reason and coincided with personal texts received and read, as well as texts typed and sent to her husband. When the defendant sent "That's good to hear" at 1 p.m., Detective Hewitt noted that within seconds, quote, Stephanie Grisham's patrol vehicle appeared to be almost completely in the oncoming lane of travel, close quote. When the defendant received a text at 1:03 p.m., asking how her day was and whether they had another Hello Fresh to do. The status of the text showed as read, and within seconds, quote, the patrol vehicle appeared to be driving on the double yellow lines, dividing the eastbound and westbound lanes of travel. At 1:17 p.m. and 41 seconds, a text message was received and read. And again, Detective Hewlett wrote, quote, the patrol vehicle appeared to be almost completely in the oncoming lane of travel. The court can see that as she drove, she drifted entirely into the oncoming lane before colliding with Robert Beal. At 1:23 and 0 seconds, an outgoing message. It's going, we had them all, oh we might. And 10 seconds later, at 1:23 and 10 seconds, I got into a crash. Based on the evidence, the last thing that Stephanie Grisham saw before the crash was her screen on her phone as she typed, oh we might. The last thing Robert Beal saw before the crash was Stephanie's Ford Explorer speeding toward him in his own lane. Once recovered enough to use her phone again, Stephanie just hit send on what she had been in the middle of typing before the crash, and then sent out, I got into a crash. I relay these facts to the court not in order to say that Stephanie Grisham is a terrible person. No one here has said that, no one is claiming that, nor is anyone claiming that Stephanie set out that day to kill someone. But this court is being asked to sentence Stephanie for deciding to text and drive, resulting in the death of Robert Beal. Sadly, lots of people text and drive. In the state of Idaho, the penalty for using a cell phone while driving is a fine of $131.50. So while this court should fashion its sentence, at least in part, on the decisions and actions of Stephanie Grisham that day, the result of those decisions is the reason the people of Idaho have decided, through the legislature, that the sentence should be up to 365 days in jail. The result was the homicide, the death of a human being by another human being, of Robert Beal. Excuse me, the sentencing factors the court should look at are, in statute, 1925-21. Interestingly, people often misread these. And so I want to go through what it actually says. One thing it is not here is comparative justice. What did another judge do? We can look back through news stories, other cases, and some judges have done very little, as Mr. Wilkinson indicated. Other judges have done 118 days per person that died. Other judges have done more, other judges have done less. But that's not a factor the court is to consider. The court is to consider first the protection of society, which is a focus not on the defendant, but on society. The second, oftentimes summarized or brought down to rehabilitation, but that's not actually what it says. The possibility of risk reduction through rehabilitation. It is not a focus on the defendant so much as it is a focus on society and the risk to society and the possibility of reducing that risk through rehabilitation. Third, deterrence of the individual and public generally. Fourth, punishment or retribution for wrongdoing, and again another one often left out, and the impact on the victim. The statute goes on to list mitigating factors, and the state recognizes that many of them apply. Stephanie does not have any criminal history. She has accepted responsibility. There's no question that she is remorseful. Her prior service to the community is a mitigating factor. But there are applicable aggravating factors that dictate a lengthy jail sentence is appropriate. Her status as a law enforcement officer should be taken into account, not just because she was a law enforcement officer and had certain duties to protect the community, but because of the knowledge that it afforded her. Her being a law enforcement officer means she didn't just generally know the possible dangers of texting and driving. She had personally seen terrible, likely even fatal collisions resulting from distracted driving. The other aggravating factors listed in 1925-21, such as 3D, incarceration will provide an appropriate deterrent for other persons in the community. 3C, incarceration will provide appropriate punishment and deterrent for the defendant. 3B, a lesser sentence will depreciate the seriousness of the defendant's crime. All factors in sentencing should be taken into account, but in a homicide case, the impact on the victim cannot fall behind another factor like the possibility of risk reduction through rehabilitation. The victims in this case, Robert Beal and his next of kin, including his wife Linda Beal of over 60 years, his 5 siblings, his 4 children, his 35 grandchildren and great-grandchildren, even several of the 61 foster children that Linda and Robert fostered over the years, will miss out on being able to see Robert at their birthday or wish him a happy birthday themselves. With those foster children that are still close, I counted a minimum of some 55 people. If the court were to look at just the birthdays missed over the past year and during the 2 years of supervised probation that the state will request, that's 165 birthdays missed. Or, starting tomorrow, that's 55 victims who will suffer through the anniversary of Robert's death. This year, and in the next 2 years, the state will request another 165 days. If you were to just put together those 2 major year events that are unalterably impacted by Stephanie Grisham's decisions and the results of her decisions that day, you'd come close to the 365 days of jail that the state is going to be asking for. However, the state is only asking that 180 days of those be served initially and the remainder suspended. If the court were to impose all 365 days of jail that are available to it, it wouldn't bring Robert Beal back. It wouldn't heal the tragic loss in the family's lives. But anything less than 180 days served in jail diminishes the value of Robert Beal's life. It depreciates the seriousness of the defendant's crime and impacts the victims again. The court may wonder why supervised probation is necessary given the defendant's lack of criminal history. In the defendant's sentencing memorandum, and again, defense counsel talked about it, Stephanie intends to be part of programs designed to educate teenagers and others about the dangers of distracted driving. And that is a good thing, absolutely. What message would it send those teenagers if a year or 18 months from now they were to ask, and what is the result? What do you have to do now? And she were to say, I have to do community service and I'm on unsupervised probation. A vastly different message would go to those teenagers, to the community that needs to be deterred from this same action if she were to respond, I had to do 180 days in jail. I still have to regularly check in with my probation officer. I have to make sure that I'm compliant, or I'm still going to any counseling that my probation officer recommends. And if I mess up again, I have another 185 days that I could go right back to jail for. For these reasons, the state's recommendation is that the court sentence the defendant to 365 days in jail, suspending all but 180 of those days, and place her on 2 years of supervised probation with an appropriate number of community service hours. The state is not asking for a fine and will leave any remaining terms, such as a license suspension, to the court's discretion. Finally, the state asks that the court retain jurisdiction over restitution for a period of 60 days. Counsel and I have talked about that. There may be a request, but we would again ask that the court retain jurisdiction over that. Thank you for your time.
Thank you.
It's been quite a heart-wrenching morning. Cannot be understated, cannot be overstated that there was a horrific crime that occurred. The loss of a pillar of this community, a person who fostered dozens of children and opened his home. I don't think there's anything that I can say that hasn't already been said. There is never a good outcome. Nothing that this court can do will ever heal the wounds that have been inflicted upon the family. One of the great crimes that occurred in this situation was the loss of association. And it dawned on me by hearing the many heartfelt comments and letters from the victim's family, and the fact that that association, at least in this lifetime, will never be had again. And it was Carla Dunthorne who indicated that, she will never had a chance to say goodbye to her father. Linda would never have a chance to say goodbye to her husband. And John to his brother. And perhaps more than the loss of life, but this takeaway from the opportunity to even say goodbye. And not only that, something that Carla said that dawned on me as perhaps weighing on the court, and that was the fact that Mr. Beal, Robert Beal, was victimized again. It was his wish not to have an autopsy done upon him, yet it was beyond his control. And that's not something that Carla should feel guilty about in any way. That was beyond her power to negotiate at the time of his death. But so much pain and suffering that the Beal family, the Clark family, the Dunthorne family have suffered over a moment. Well, it wasn't really a moment. It was actually about 17 minutes of distraction. Some of the things that the court weighs and the court takes into consideration, besides 1925-21, and the court's very well versed in 1925-21, as well as the different decisions that have come down by the Idaho Supreme Court regarding sentencing. Even though the Two-Hill decision is one regarding a felony matter, and this is in fact a misdemeanor, the court still looks for direction to that decision as to what the court should do. I think both sides have appropriately instructed the court on 25-21. The court looks at all those as important factors in sentencing. Of note, the court takes a look at the particular sentence and whether or not the particular sentence would lessen the seriousness of this particular crime. In looking at that, what the court looks at is the court looks at the knowledge that Ms. Stephanie Grisham had at the time of this tragic crime, and that was the fact that she was driving a patrol vehicle that in and of its nature is outfitted as a vehicle that can overcome other vehicles. I mean, it's used to stop other vehicles, to force them off the road, and otherwise engage in law enforcement activities that make them more powerful than other vehicles. This in of itself, the court would think would make somebody who is driving one of these vehicles more cautious. The other issue that's been brought forward that dawns on me as very serious is the knowledge that Ms. Grisham had at the time of this crime, and that was, I believe, the state adequately said that she knew of the dangers of texting and the dangers of distracted driving. Some of the other issues that I'm looking at here is the position of the victims, and I don't regard just Mr. Beal as a victim. I actually regard just the community as a victim, just because of the enormous loss, because of the services this man was providing to the community. And that cannot be overstated. The fact that he was involved in so many lives and gave so much of himself has merit and has value that will forever be lost. Even with all that, and the broad impact that this has had upon the family, Linda Beal and John Beal both looked at the greater good that could be had from it. And I think everybody who spoke today testified and commented on that. Robert would want something to emerge from this huge tragedy, something positive. And the court cannot appreciate enough Linda and John's recommendations as far as community service goes in this case. And I think it just speaks a lot to their character and the character that Robert had on their lives, the influence that he had on their lives. The fact that they would come in making this recommendation. It actually isn't surprising to me that Linda would make this recommendation, where she's been the mother to so many foster children and has been a help to so many of those around her, that she would come in and make this recommendation that Stephanie otherwise engage in rehabilitative justice. And the court's going to make that a part of its sentence in this case. Certainly this impacts not only Robert's family, but Stephanie's family as well. Stephanie's been a law enforcement officer for a number of years. She's lost her career. She has lost her ability to do that which she wanted to do as well. It's impacted her children, it's impacted her husband, it's impacted her co-workers. And so what has been said, one of the famous quotes of Robert is correct. I mean, you can, and it's interesting that this quote was brought up because it's something I use on a weekly basis, especially when addressing defendants, as well as particularly my juvenile defendants and juvenile court in Bonneville County, and that is you get to make your decisions, but you don't get to make your consequences. And that resonates with me because it's really the truth, and it's exactly what we are talking about here today. And in this particular situation, the consequences have rippled not only through the Beal family and the Bingham County community, but also through the Grisham family in ways that we'll never understand the consequences of those ripples. And we will never understand those for years to come. I'm going to go through the first, the conditions, the specialized conditions. I am going to place Ms. Grisham on probation. The court's going to place Ms. Grisham on probation for a minimum period 2 years. That's going to be followed by a fine of $2,000. The court will approve a payment of not less than $100 per month, plus the fee. Court's going to order 100 hours of community service, 60 cents an hour for the cost of a workman's compensation insurance associated with that community service. Court's going to order that at the very least 50 of those hours are dedicated to rehabilitative justice, particularly instructing the youth on the dangers of distracted driving. The court is going to retain jurisdiction for restitution purposes. However, the court is going to order Ms. Grisham to pay for the cost of burial of Robert Beal, all costs associated with them. And the court will wait for further motions regarding restitution. Court's going to suspend Ms. Grisham's license to drive for a period of 3 years. There will be absolutely no driving. Yeah, that suspension will start today.
Did you say 3 years, Your Honor?
3 years. costs as well. As far as incarceration, the court's heard arguments in considering incarceration, in considering the ends of incarceration. The court identifies those factors as well that I've already mentioned. The court's heard and has received evidence, well, not evidence, but a report regarding the PTSD that Ms. Grisham is suffering. I imagine the victims are suffering PTSD as well. I imagine that they're going through their own counseling. And so the court focuses on its sentence and whether it would not, what I would do would diminish the seriousness of this particular crime. The court is very limited in what it can do. The maximum that it can impose is up to 365 days. The maximum fine is $2,000, which the court has done. And regarding the issue of incarceration, the court is of the belief that a person's life cannot be taken without doing jail time. I just can't get beyond that, particularly in this situation, with the loss of association, the loss of this man's wife, the loss of this pillar of the community. Anything else but some sort of incarceration would really diminish the penalty, or diminish the facts of this particular crime. And it goes without saying that that Ms. Grisham did know what she was doing at the time, and she had a particular vehicle, as I indicated, that just wrecked devastation on this truck. The fact that this truck was mangled in the way it was is quite astounding to the court, given the fact that the court is very familiar with larger vehicles. But Ms. Grisham, despite having control of a vehicle designed to inflict this kind of damage, still engaged in negligence. And in fact, after a review of what I've seen today, I would even go far as to say that this was gross negligence, given the fact that she had this knowledge and she had the means to wreak this devastation. For that, the court is going to impose 365 days of jail. The court's going to suspend 185 days of jail, leaving 180 days to serve. The court finds that serves the end of justice. The court will not allow work release at this time. The issue of whether or not Ms. Beal should have some sort of furlough in order to complete her counseling will be taken up at a later time and upon motion. Court is remanding Ms. Grisham to the custody of the Bingham County Sheriff now. She'll be taken into custody now. As far as where she will be doing her sentence, that will be at the discretion of the Bingham County Sheriff. Ms. Grisham, you have 42 days from today's date to file an appeal in this particular case. There also may be issues related to post-conviction relief, as well as Rule 35, and I will allow you to take those up with your attorney. The court is in recess.